to investigate him. And then in this affidavit, and I'm at paragraph 32, I demonstrate that the IPID, by permitting O'Sullivan and Trent to lead their investigation into the Patlani matter, runs contrary to the very independence and impartiality the IPID Act seeks to protect and guarantee. And then importantly, at paragraph section 25(1), importantly because it relates to the core of the charges that I preferred against the suspect. Section 25(1) of the IPID Act further provides that no member of the directorate may conduct an investigation in respect of a matter in which he or she has a financial or any other interest which might preclude him or her from exercising or performing his or her powers, duties, functions in an objective manner. So this section deals or refers to a situation where an investigator is related to a person and then involves that person in an IPID investigation, whether that person is related to that person as a friend or as a person who has at some stage helped him financially, or maybe where the person is related to him, where he's a wife to him. He cannot involve those people in an IPID investigation. And then section 25(2) provides that if during an investigation it appears to a member of the directorate that a matter concerns a financial or other interest of that member as referred to in subsection 1, that member must, 1, immediately and fully disclose the fact and nature of that interest to the executive director and withdraw from any further involvement in that investigation. We know that the IPID members, the Patlani task team, had these kind of relations with Sarah Jane Trent and O'Sullivan, where there were favors exchanged amongst and between themselves, the interest being to see General Patlani being removed as a national director or suspended. So the evidence is there. I will set it out during my affidavit and refer to real evidence. Section 33(2) provides that any member of the directorate who willfully discloses information in circumstances in which he or she knows or could reasonably be expected to know that such a disclosure will or may prejudicially affect the exercise or the performance by the directorate of the powers and functions is guilty of an offense. Section 33(4) provides that any member who fails to make a disclosure in accordance with section 25(2) or fails to withdraw in terms of section 25(2)(b), as the case may be, is guilty of an offense. Even the regulations, regulation 10.1 of the regulations for the operation of the Independent Police Investigative Directorate provides that all information, whether verbal or in writing, and all documentation acquired during the course of an investigation conducted in terms of the Act and all records pertaining to any such investigations are to be treated as confidential and may not be divulged to any person outside of the directorate unless authorized to be divulged in the interest of justice by the executive director or relevant provincial head, as the case may be, in writing or an act of Parliament. Now, several of the charges against the IPID members related to this contravention of section 33.
And yes, you conclude at paragraph 38 that your submission is that the accused and the suspects in that case have all contravened these provisions that you've referred to.
Indeed so, Chairperson. Now, I also highlight at paragraph 31, the definition of the Prevention and Combating of Corrupt Activities Act.
31 or 39?
39, oh, sorry, Chair, 39. And then section 1 of the Prevention and Combating of Corrupt Activities Act, number 12 of 2004, provides the definition of gratification to include money, whether in cash or otherwise, any donation, gift, or loan, any forbearance to demand any money or money's worth or valuable thing, any other service or favor or advantage of any description, including protection from any action or proceedings of a disciplinary, civil, or criminal nature. We have heard before this honorable committee that Mr. O'Sullivan admittedly made a contribution of 200,000. I think he said 200,000 for the legal expenses of Mr. McBride, and that was during the period that Mr. McBride was suspended. So immediately thereafter, in November, Mr. McBride was reinstated. Same time, O'Sullivan now approaches Mr. McBride and then involves himself in the investigations against the General Patlani. Now, that definition, which says including protection from any action or proceedings and forbearance to demand. So it demonstrates to us that he paid that money for the legal expenses of Mr. McBride as a forbearance for him now being involved in the investigation and exercising the functions and powers of IPID.
So that amounts to gratification?
That amounts to gratification in terms of the act. And then I deal with the other contentious issue of the National Credit Act. Mr. McBride and Mr. O'Sullivan said there's nothing wrong with a person accessing the credit information of private citizens. In fact, that is a very, very dangerous contention by them. So I deal with the National Credit Act 34 and under section 68(1, provision is made there that any person who in terms of this act receives, compiles, retains, or reports any confidential information pertaining to a consumer or prospective consumer must protect the confidentiality of that information and in particular must use that information only for a purpose permitted or required in terms of this act, other national legislation or applicable provincial legislation, and report or release that information only to the consumer or prospective consumer or to another person to the extent permitted or required by this act, other national legislation, or applicable provincial legislation, or as directed by the instruction of the consumer or prospective consumer or an order of a court or tribunal. Now, the regulation 18 4 of the National Credit Act regulations as amended by the 2015 regulations provides that the prescribed purposes other than for purposes contemplated in the Act for which a report may be issued in terms of Section 70, subsection 2G are inter alia. 1, an investigation into fraud, corruption, or theft, provided that the South African Police Service or any other statutory enforcement agency conducts such an investigation. 2, fraud detection or fraud prevention services. Now, I'm stating this fact because we know from the information, and when we were even able to obtain a statement from TransUnion as to the reason why O'Sullivan and Trent accessed the credit reports of private people. Now, we know that they used this 42.2 reason, fraud detection or fraud prevention, but they cannot, they are liable in terms of the contravention of the Act because there was no complaint of fraud made to them in the first place. Secondly, other than that, there was no fraud and detection. We know that the witnesses whose credit reports were accessed were not suspects. In fact, the witnesses were state witnesses in their in IPID's own investigation. So why did they have to investigate their own state witnesses? And then finally, I referred in paragraph 43 to section 86(1) of the Electronic Communications and Transactions Act, and it relates to also the accessing of the credit information, which says subject to the interception